Welcome to the 19th episode of Seminal Group's podcast, Alternative Litigation Strategies, where I interview esteemed members of the bar from the top law firms and legal institutions from all across the country. On this program, we discuss the latest litigation trends and settlement strategies that are currently happening across the entire spectrum of commercial and class action litigation, including Biometric Information Privacy Act litigation, which is going to be a special focus of our program here today. I'm your host, Kevin Skrzowski, with the litigation consulting firm Seminal Group, and today I am pleased to be joined by Ken Suh, Senior Counsel at Locke Lord and a member of the firm's Privacy and Cybersecurity Practice Group. Ken, it's a pleasure to have you on the program today.
It's a pleasure to be here, Kevin. Thanks for having me.
Wonderful. So now, Ken, today we're going to discuss the surge in BIPA filing since the White Castle decision. But first, can we start by having you tell us a little bit about your business career and your practice at Locke Lord?
Sure. I've had a little bit of an untraditional legal career. I started out a professional career as a consultant working for IBM, doing some technology consulting. I really enjoyed working with businesses, solving some of their, at the time, post-Y2K technology issues, and transitioning from legacy systems to what we would consider today more modern systems. Gained a real interest in some legal issues that were popping in the early 2000s. And a good friend of mine actually convinced me to go to law school. My practice primarily right out of law school was in technology-related litigation, patents, contracts, copyrights, and trademarks, but also included any kind of component that had a technical feel to it. I transitioned over to privacy law about 5.5 years ago now. And at the same time, I pursued an MBA at the University of Chicago, Booth School of Business. And I have a startup that I've co-founded with a couple of classmates. And we're hoping to get that off the ground. It's a startup that's designing a telemedicine app for cardiologists.
Very interesting. I think that's fascinating. And I always find it fascinating when I speak with lawyers who had a prior non-legal career, and then they leverage everything they learned in that career to transition it into another successful career practicing law. And in your situation, it sounds like almost like a third part of a trifecta, which is becoming an entrepreneur as well. So congratulations on your business venture, and I wish you all the best there. So that's probably why Bloomberg Law has reached out to you for comment so many times this year. I know you've been quoted several times in Bloomberg's legal periodicals about decisions in Biometric Information Privacy Act cases, including most recently, there was an article titled, Illinois Biometric Privacy Cases Jump 65% After Seminal Ruling. And I want to dive into that. But can you start by providing us with an overview of the Biometric Information Privacy Act? What is it and what does it cover?
Sure. It's an Illinois law that requires private entities that collect biometric data to receive written consent from employees and consumers and develop a written policy about the collection, retention, and destruction of that biometric data. The law defines what biometric data is, and it has a broader meaning, but the most common examples are facial recognition, retina scans, and fingerprints. And I should also add, it's the nation's first standalone biometric data privacy law.
That's interesting. And it's actually been in effect for quite some time, right? Going back to 2008. And then the technology almost developed after the fact, correct?
That's correct. And I think that there are many skeptics who always say that the law is always behind technology. And certainly my practice, I hear that quite often. But I think in this case, the law may have been ahead of technology, and some things that you and I may have been seeing in the movies have finally come to fruition in real life, and the law's become more relevant.
And that's what I want to ask you. So, I mean, you say fingerprints and facial recognition and optical recognition. What are you talking about exactly? Like scanning your eye to get into your place of employment or to get into your computer to punch in and punch out? Is it really that prevalent these days?
Yeah, those are great examples and examples that we have seen in BIPA cases. I think the most prevalent thing we've seen are just the replacement of time clocks. I am just old enough to have punched in and punched out of my first high school job, but those are all gone now, and they've been replaced by thumbprint readers, where you just put your thumb next to a small reader. It identifies you, and you've clocked in for your job. You put your thumb there when you clock out. But we've also seen examples where companies are using this for things like safes that hold valuable information or valuable personal effects. And in the retail space, you may have gone into a store, or you or your loved one may have gone into a store and been able to try on makeup on a screen without actually having to put the makeup on your face. So we've really seen the technology expand quite quickly and the use cases expand quite quickly and in fascinating ways.
So this is technology that is becoming ubiquitous across businesses and industries.
Yeah, that's correct.
Very, very interesting. Now, there were two significant Illinois Supreme Court decisions this year. There was Timms versus Black Horse Carriers, and then just a few weeks later, there was Cawthron versus White Castle Systems. Can you take us through the significance of these two decisions this year?
Yeah, so these are cases that have been watched for quite some time. And because they're two issues that were never answered and are kind of ambiguous based on the face of the law, but what Black Horse said was that a 5-year statute of limitation applies to 3 very specific portions of BIPA. The defendant in that case had argued that a 1-year statute of limitation should apply. And just by way of background, that's the default when it's not specified for certain types of lawsuits. The White Castle case increased the possibility of large fines by concluding that there's a violation each time a business fails to seek permission to collect biometric data from workers or consumers. This is sometimes called the per scan ruling because the court essentially said there's a violation every time you scan the fingerprint and don't receive consent from your employees.
So every time an employee, let's say if they scan in, scan out for break, scan back in, scan out for lunch, scan out, and there's hundreds of employees, you could be looking at thousands of violations per day, for example.
Exactly. Thousands of violations per day, going back now 5 years rather than 1 year. And so coming into this year, there was a possibility that the court could conclude that a 1-year statute of limitations applies and only one violation, regardless of the number of scans. The other end of the spectrum is where we ultimately landed, which is there is a 5-year statute of limitation and a violation for every scan that occurs.
So definitely with these two decisions, it opened up massive liability and exposure for businesses that utilize this technology. So what are the statutory penalties?
Yeah, so the statutory penalties are $1,000 or $5,000, depending on the nature of the violation. And of course, that could rack up to hundreds of thousands of dollars a day, depending on the number of employees you may have or the number of consumers you may interact with and how long the system's been in place.
Now, the scary thing about that is that you're really talking about bet the company litigation or like shuttering a business's doors if the statutory penalties rack up as quickly as they can. I know BIPA is relatively new in the class action space, which is where Certain Group and I operate daily. I'm familiar with TCPA, which is the same level of penalties, and companies can make hundreds of thousands of phone calls. And I don't think it was ever the legislative intent that companies would be exposed to hundreds of millions of dollars of liability to shutter their doors. So with these statutory penalties of $1,000 and $5,000, so if they go to trial, are these mandatory penalties, or is there a judicial discretion to perhaps give plaintiffs an award, but not really require the business to shutter the business?
Sure. And this has been a kind of a hot topic of discussion since the White Castle case. And just for background, there's only been one case that went all the way through trial. But there aren't a lot of data points to say how courts are actually interpreting the statute for damages purposes. But the White Castle case kind of left open the possibility that damages are discretionary and pointed to a portion of the statute that said the prevailing party may recover damages. The court also said, there's no actual language or record anywhere that says the legislature intended to create some kind of ruinous damages award for companies. And I think that's kind of keeping in line. You mentioned TCPA. In those cases, courts ultimately also kind of landed in this place where they said, we're not trying to put people out of business, but you still have to be able to compensate for privacy violations, particularly when it's statutory. I think that the interesting part about the White Castle decision is that the court also appeared to say, we're going to deal with that maybe in the future when there's a case that has those facts in place. There's a small part at the end of the decision where it says, well, ultimately, these are kind of policy concerns at this point, and the idea of excessive damages awards are best addressed by the legislature. So they didn't say that it's only a legislative issue, which they could have said, to say that courts are powerless to affect the damages in any way. But they also didn't say that courts should do certain things. So they didn't provide guidance. And my own view is that they are potentially looking for a case where this would be an issue, that they could decide on those facts, or potentially signaling to the legislature that they do need to act if they feel like this is impacting businesses in the state.
So I think your point about there haven't been a lot of cases that have gone to trial has been one. This is very interesting, but also it's a matter of the legislative intent. Personally, I think that it would be very difficult for a legislature in the state of Illinois to sort of like peel back these statutory violations for businesses and not take more of the consumer sided opinion in the whole matter. So I think that would be really tough to do in Illinois.
Yeah, and there are, I think, 5 or 6 pending pieces of legislation right now that address everything from the scope of the law, statute of limitations, to damages. So there is some hope that one of those will make it through, but we've also seen that in past years where potential pieces of legislation have come up, gone to committee, and haven't made it very far. I think that's the unique thing about this piece of legislation is that there are potentially bet the company issues here. And ordinarily, those are associated with things like key products or services that a company offers that might be in jeopardy. And here, this BIPA addresses privacy concerns. So I don't think there's a history of thinking about it quite in the same way.
No, I think you're right. And I think we'll have to see how it plays out in the legislature and in the courts. So speaking of the courts and the article that you were cited in Bloomberg recently, that statute of limitations and that damages expansion did lead to a surge in litigation. Talk to me about the surge. How many BIPA cases were we seeing on a monthly basis before these rulings? And then how many started to come in through the courts after the decisions?
Yeah, the 2 months before, there were about 74 cases filed. And then in the 2 months immediately after, there was over 120. So it's a significant increase. We are hobbled a little bit by the information that's available to us, but I don't think anyone would dispute the trend in that increase.
It's definitely a popular filing among the plaintiffs bar. Now, do you think that the filings are going to continue at this brisk pace? And if so, why? I've spoken with some other lawyers who looked at this most recent month and they said they've almost begun to increase a little bit. So what are your thoughts on that?
Yeah, so I'll kind of start off by saying I've gotten out of the crystal ball game. Usually I make predictions on trends, and then I learned some valuable lessons about making predictions. So I'm not sure exactly where it will go, but I think for the first time, we have clarity on what the law says. We have clarity on the 5-year statute of limitations. We have clarity on the per scan issue. And that just means there's a greater financial incentive to bring these lawsuits. And of course, that usually coincides with a higher number of filings. And then, kind of separately, even though I'm mostly a defense lawyer, I think there's growing awareness about privacy. And that's a good thing. Now, we can debate whether BIPA's executed perfectly or if there's some rough edges to iron out and if this was actually the intent of the legislature. But generally speaking, I think we like that consumers know more about their privacy rights. It's something that the general public is more concerned about. So all those things kind of play together, and I think there will be an increase in litigation around BIPA.
Yeah, I think those are all wise and accurate statements. I think many of the general public may not be familiar with the Biometric Information Privacy Act, but everybody is certainly in tune with privacy rights, data breaches, protecting your personally identifiable information, safeguards, looking out for fraud, things like that. It's top of mind and it's in the mainstream media. So I definitely think, again, not to look into a crystal ball along with you, but we're going to continue to see this for some time. So who are the primary targets of the plaintiffs bar? I mean, are they going after like large businesses with massive numbers of employees that they may have sort of like a cash cow of exposure, or are smaller businesses, equally open to this type of exposure now?
We're seeing exposure for all business sizes. The bigger companies obviously have more employees, and they may have had earlier access to this technology. So it may have been in place for longer. So that's certainly a fact that's favorable for plaintiffs. On the other hand, smaller companies may not have the appetite to defend litigation for long periods of time. So that would be favorable for quicker settlements. there's no real profile. And I think one of the interesting things we've seen the past 2 or 3 years is that there tends to be waves of industry. So initially we saw a lot of retailers hit, and then we saw a lot of lock companies hit, companies that actually provide biometric scanning equipment. And then we saw the service providers hit. So, these aren't perfect trends that you can segregate, but you can start to see that industries are being targeted one by one. And then if there's some success, then they continue to be hit.
Very interesting. So in terms of companies of all shapes and sizes being targeted, and you had mentioned it may be even more difficult to defend for smaller companies. What impact do you think it will have on settlements? Do you foresee, not to make you look into the crystal ball again, but will this lead to more class-wide settlements? And we really haven't seen any yet.
I was actually just talking to a colleague about something like this earlier today, and I hesitate a little bit to answer something specific to BIPA because I think in many ways this is not that different from other types of litigation when it comes to settlement strategy. And of course, we always advise our clients, you have to start prioritizing what's important to your business. And if it's important to resolve issues as they come up as quickly as possible, then individual settlements might make sense. But on the other hand, we've seen individual settlements become kind of a trap for clients, where the first one leads to the second one, leads to the third one.
And it leads to repetitive filings because you don't get a full release.
Exactly.
Yeah.
And so whether it's BIPA, general privacy class action litigation, or the pixel litigation you may have heard of, it's all similar concepts. The execution is obviously different because of the specific facts, but those are the things we ask our clients to think about.
And that's a core objective of our business. Normally people come to us, they're looking to ensure a class-wide settlement. And in doing so, they want the broadest release as possible. And we always provide guidance that if you achieve that release, then you don't have to worry about a copycat lawsuit being filed the next day. So final question for today then, what advice would you give to a client to make sure that they're compliant and they avoid potential litigation?
I think just pay attention to general trends. And, everyone's busy. So whether you're a small business with 2 locations or a Fortune 100 company, everyone's very busy. And so it's hard to keep track of all of these. But with something like BIPA that's making headlines in things like Cranes and the Wall Street Journal, I think it's tough to say that you didn't know this was an issue generally. It's just information that's available to most companies. And then the second thing is to have a compliance program. Now, obviously, budgets are limited and everyone is trying to do the best they can with the budget they have. But again, just like any decision a business makes about investments in equipment, people, compliance is an investment. And the way we talk to our clients is to say, well, you kind of have to compare the cost of being compliant with the cost of one violation. And the numbers are very favorable to be compliant and not regret receiving one of those demand letters. So that's what we advise our clients. I think one of the things that we're seeing generally is that there's just this widening gap between companies that are very prepared and compliant from a privacy perspective and doing the belt and suspenders approach, and then companies who just are struggling, not just with BIPA, but all the other privacy statutes that are coming online. So that's just one of the things that I think businesses have to face because of the patchwork we have.
Well, I think those are very wise and insightful final thoughts. That's really about all the time we have for today. So, Ken, it was a real pleasure having you as my guest, and I want to thank you for all your time and the valuable insights that you shared with our audience today.
Thank you for having me.
Now, if anyone would like to contact you to discuss any of the topics we covered here, what would be the best way to reach you?
Yeah, best way to reach me is just by email, and it's my first name. It's Kenneth, KENNETH last name, which is SUH at lockelord.com. You can also just Google my name and Locke Lord, and it should come up in the first 1 or 2 results.
Great. Thank you, Ken. And of course, as always, I'd like to thank the audience for listening. If you'd like to hear more, please be sure to follow us on Apple, Spotify, Stitcher, or anywhere you listen to your favorite podcasts. If you'd like to listen to a recording of today's program or like to learn about any litigation insurance or funding solutions that Certum Group provides, including class action settlement insurance, which effectively transfers the financial risk in claims made settlements away from defending businesses, please visit our website at www.certumgroup.com, or you can always reach out to me directly at kevinus@certumgroup.com. Thank you, and until next time.